This courtroom doesn't simply begin, it ignites. Every visual detail matters here. The upside-down American flag, the defendant's late entrance, the posture, the confidence. These are not accidents, they're signals, signals of defiance, signals of ideology. From the very first seconds, this isn't just a sentencing hearing, it's a collision between personal belief and institutional authority. The judge immediately asserts control, not with anger, but with calm precision. And that calm is deliberate, because when someone walks into court believing the rules don't apply to them, the system responds not with emotion, but with structure. The tension you feel now, it's only the beginning.
Today we are going to witness the opening of a courtroom showdown that sets the stage for chaos. From the upside-down American flag to the defendant strutting in late, the judge wastes no time calling out his antics. Already, the tension is palpable as we see the clash of a sovereign citizen ideology versus the hard, unyielding legal system. This is the perfect hook for what's coming next.
Thompson, file 24-3559-H. Miss Williams, he has arrived in the court while we were handling that other file. The court recognizes Mr. Down. Yeah, Mr. Thompson says. Oh, wait, she's handling it. Disregard. Sorry. The court recognizes Assistant Attorney General Miss Williams. I can't remember her first name. Karina?
Carissa.
Carissa, I was close.
Carissa, yes.
Thank you. The court also recognizes here, join us, Mr. David Glenn Thompson, who's the defendant, who's appearing in pro per. Sir, you may have a seat. The court also recognizes Mr. Lou Flazak, an agent from the Michigan Department of Corrections, who has prepared today's pre-sentence investigation report. We are here today for a sentence in a case after a conviction by a jury trial. Earlier, when the defendant failed to appear, we knew that he was having some issues, but it took longer. The court had issued or said it would issue a bench warrant. Of course, I withdraw that. And we're now here for sentencing. Mr. Thompson, we've covered this a couple times previously on the record. Are you still representing yourself pro per?
Yes, sir.
All right, thank you. Have you received a copy of this pre-sentence investigation report?
Yes, I just got that. Unfortunately, I haven't been getting the mail, the forwarding address.
Okay.
So I got it just a few days. Actually, I picked it up from their office.
All right. Ms. Williams, do you have a copy?
Yes, I do, Your Honor.
Any corrections, amendments, or at all to make, Ms. Williams?
None from the people, Your Honor.
Thank you. The court will also recognize that while Mr. Robert Champion from the Western Misaki Public Defender Program is not generally appointed or typically appointed here, he is appearing as advisory counsel, which he did during the trial. Mr. Thompson, do you have anything in here that you think is incorrect that we need to correct, or that there's any errors?
It looked like everything was correct, Your Honor.
And sorry, Mr. Thompson, it's because you're representing yourself. I just need to let you know, typically at this stage of the proceedings, I always have to ask each side if they have any corrections. So each side does not have any corrections. So now I'm going to turn to Ms. Williams. Ms. Williams, allocution, ma'am.
We would just ask that the court adopt the recommendations in the pre-sentence investigation report today. Thank you, Your Honor.
All right. Thank you very much. Allocution is, again, an opportunity, and forgive me if you already know I'm not trying to be insulting, as an opportunity that you can make a statement as to mitigation, extenuation, whatever you wish to say about the that you want me to consider. Sir.
Excellent. Yeah, approach, Your Honor.
Do you have something to provide?
Yes, I do.
Yeah, sure. Go ahead. Yes, you may.
And I apologize again for being tardy this morning.
It happens.
I put the occasion.
Williams, what I'm receiving here, and I think it's probably appropriate. It is a statement that comes from the bankruptcy court for the Western District of Michigan, and it just says that he has applied for bankruptcy. That's all. I think that's relevant only because it talks about ability to pay. Any objection to me considering that, Ms. Williams?
No, Your Honor.
Thank you very much. Yes, sir. Back to you.
The recommendation, it's the page, without any disrespect, to me is unacceptable as it sits. Trying to get my life back together. I've not seen my daughters in almost 3 years now. I have it's been a really slow process, and one of the things that I've learned, I love to play pool. So I got a DUI a couple of years ago, and the court allowed me to continue to play pool. And I never misstepped with any alcohol or anything, and I was working at the American Legion at the time. So I appreciate the grace that the court has offered. And again, I apologize for being late this morning. There it is. This one, the conditions of sentencing.
I'm familiar with it. So let me help you just understand that, and maybe you do, but that appears for the record on CFJ 145, which is the type of form it is, which you'll see up in the upper right-hand corner, and it appears on pages 2 and 3 of the pre-sentence investigation report. Those are the proposed terms and conditions of probation. Yes, sir.
And looking at a term of 1 year, 12 months.
Yes, the recommendation is it to be placed upon a period of probation for 12 months. Now, if the court places you on probation, you have the right to be considered for early release from probation if you have complied with all the terms or conditions within half the time. So, for instance, when it says 12, you think, well, as long as I meet the conditions within 6, then I get off of probation. It's a right.
Okay. Yeah. The pool season for this year is still going on.
Okay.
And that's going to pick up next fall. So I'm not comfortable with waiving my rights or my inherent rights. I thought those were unalienable. So I do understand the.
And so which one of these terms or conditions are you challenging, or that you are asking me not to comply with or not to order? Like, what right do you think? I mean, maybe at most it's 11 p.m. to 6 a.m. curfew.
That's a difficult one too. I also write music, and I've got a friend that wants me to potentially perform at a wedding.
Okay.
So I'd like to get out there and do some of the things that I love, playing music, so on and so forth. The last one you waive rights you might otherwise have under the United States Constitution, the Michigan Constitution. I'm definitely not comfortable waiving any of that. The cost and everything, obviously, that's probably going to end up in the bankruptcy proceedings. And I've tried to bring a court in satisfaction, Your Honor. I'm missing something or something along those lines. I sincerely do want to take care of the obligation. I just don't have the means in liquid assets to be able to keep up. The other thing is I reopened the veterans disability right now at 90%. And I've got to get into the doctor and get some things checked out. My shoulder is still separated. Not necessarily in the greatest physical condition. Your Honor, I think it was talking about finding a job in here.
Excuse me. All right.
Cannabis has been something that has been helpful for pain relief of the back injury, so on and so forth.
Do you have a prescription?
I used to, but I let it lapse.
If you get a prescription, the court is not allowed to impact your prescriptions, by the way. All right. Anything else?
Well, to be honest, I don't want any of it.
I understand no one that comes in here for sentencing wants any of it.
Hey, I still got my sense of humor here.
I know. It's all right. I've enjoyed it.
This single question quietly raises the stakes of everything that follows. Self-representation is legal, but it's dangerous. Without counsel, every word becomes a risk, every misunderstanding a potential self-inflicted wound. The judge knows it, the prosecution knows it, and deep down the defendant knows it too. Yet he presses forward alone, convinced that knowledge, belief, or principle will shield him. In reality, the courtroom doesn't reward ideology, it rewards compliance and clarity. From this moment on, there will be no buffer, no interpreter, no legal filter. Every sentence he speaks travels directly into the record, permanent and unforgiving. Interview 3. Allocution sounds harmless, even generous. A chance to explain, a chance to humanize yourself, but it's also one of the most dangerous moments in any sentencing hearing. This is where defendants often believe emotion can outweigh facts. Here, Thompson steps into that space, hoping sincerity, hardship, and personal struggle will soften the law. He speaks of family, addiction recovery, music, and missed time with his daughters. And while the judge listens patiently, the system listens differently. It hears relevant.
Anything else?
You know what, Honor? I think my heart tells me I'm going to, given the circumstances of the bankruptcy and everything else, and all the finances and funds will be going on with that, I'm feeling in my heart to leave it the grace of the court.
All right. Thank you. You may be seated. All right. The court recognizes here that each one of these offenses for which there was a conviction after a trial score as a relatively low intermediate sanction cell. The court is governed by the law of Michigan that where there is an intermediate sanction cell, the presumption is that the court may only give a sentence that includes fines and costs as well as probation in lieu of jail. Now, the defendant didn't ask for this. I'll just note that a defendant can ask for, which I'm not saying he's doing it or wants to, but if a defendant doesn't want probation, then the court is allowed to give jail in lieu of. Let me explain that. It might seem it might seem confusing. I can only put you on probation in effect if you want to. However, if you choose not to be on probation, then I can give a period of jail. That's up to the defendant. Now, if you had Mr. Champion who was there here in the back of the room, if you had him there, he would have probably told you the same.
This is weird. I don't know why this is this way, but I don't doubt the judge. I'm sure he's saying it correctly, but he literally can't give jail unless the defendant agrees for this particular scenario.
Same thing. You have the right to say, hey, judge, it's because you say you don't want any of it. I think I'm doing the right thing by advising you that you have the right to say, judge, I'll do jail instead of probation. That's up to you. You're not asking for jail. Am I correct?
Well, not unless the under 19 they would construe 24 days as time served.
Well, when you say they, what you mean is me.
The court.
What you mean is me. Well, I'm not. I also don't get into what I would call negotiating a sentence. I don't negotiate.
Here comes the climax. The judge delivers a meticulous sentence: 24 months probation, fines, restitution, and 24 days jail credit. The probation terms are partly struck, partly enforced, and Thompson realizes the law doesn't bend to his beliefs. This is where the courtroom tension peaks. Viewers see the consequences of trying to outsmart a system that doesn't play games. The moment is tense, precise, and unforgettable.
All right.
What would be the jail time?
I haven't gotten there yet. I don't know. And I'm not going to tell you because then it looks like I'm negotiating. So let's not open up that can of worms. I do see Mr. Champion walking up. I'll give you just a moment, Mr. Champion. All right. So
He does not want to go, Your Honor.
okay, I didn't think he did. Not many people do. Once in a while, by the way, you'd be surprised. Some people have a real hard time staying off of controlled substances, and they just know they're going to violate. So here's what the sentence.
Matt,
Sure.
and I've been up a few times, and I was in a place in Buncombe County, North Carolina, and I realized why jails exist.
Yeah. All right. All right. So here's the sentence of the court. The court assesses as required. I'm sorry. Hold on. The court is going to sentence the defendant to a period of probation for 24 months, and I'll explain why in just a moment. The court adopts the terms or conditions for probation that are listed on CFJ 145 pages 2 and 3. However, the court will strike paragraph 1 regarding possession of substances that are illegal. That's fine. He can enter bars or places that there was one drinking and driving, but I don't see anything in here that demonstrates a substance use disorder that's active and that I need to be concerned about here today. Also, the court will strike paragraph 2 because there doesn't need to be any testing for that substance. However, the court will, which these are standard, not to possess or use controlled substances. It will take away from that marijuana because it's legal. Does it make sense, Mr. Blazak? So we strike paragraph 1, strike paragraph 2, keep in paragraph 3 and 4, and but that doesn't apply to marijuana, which is a legal substance.
Okay.
All right. The remaining paragraphs, I believe, are well, you know what? I'm going to strike paragraph 10. I don't think I need to put a curfew on the defendant. There hasn't been any issues. When I looked here at his prior criminal history, I saw there was obviously we held a bench issue here in this file, but I don't see any other justification for the curfew. By the way, Mr. Blazek, I did note one small typo, and that is on CFJ 284, page 4, underneath entry 2 of 10, where it says charges at arrest. It says DV, which means, of course, domestic violence, protection order, and then somebody just misspelled the word violation, which I'm sure wasn't you. It's probably been in his PSI now for 20 years. Thank you. All right. Now, I do understand that the defendant has concerns about waiving certain rights. The law, however, does allow the court, while the defendant is on probation, to conduct searches, which, by the way, don't happen very often unless you are dealing drugs or we've got worries about that. So, but that's up. Now, keep in mind here, a lot of these times it says within the discretion of the probation officer. As long as you've got a good working relationship with your probation officer, if you need to get an extension or something else like that, just talk to him. Don't wait and violate and then go back and say, will you forgive me? Always ask for permission. Now, I do highlight for you that you have the right to, at halftime, if you've been compliant with all terms or conditions, you can be released at halftime, so at 12 months. Now, the reason why I'm setting the 12 months is for the 24 months is because of the amount of restitution that I have to order, right? And you also have another file going on in the bankruptcy court. So by giving you a year, we'll see how things work. So the court assesses two $68 state minimum fees, which is required by law. Also is the $130 Crime Victims' Right Fund fee. The court assesses a $300 court cost, a $500 fine, I'm not going to do any attorney fee. Was there a DNA fee here, Mr. Blazak?
I don't know.
Ms. Williams, normally in your file, there should be either a order or somebody would have checked and said DNA was already available. I'm going to suspect DNA was already available because I think he had a prior felony. Didn't he?
I can try to.
No, this is the first felony. This is the first felony. Madam Clerk, do you have any orders there?
I do not have an order.
All right.
Your Honor, number 29 relates to the Constitution.
Yeah. Hold on. I need to take care of this. Don't derail me. Did you have to go to the jail and take a DNA swab?
I believe they did at one point, yes.
All right, Madam Clerk, could you issue a DNA order?
Yes, sure.
Thank you. Then the court will add a $60 DNA fee payable to the Missaukee County Sheriff Department. The court also assesses restitution and the amount that's contained in the pre-sentence investigation report, which is $14,691.54 payable to the Missaukee County Clerk on behalf of the children. Anything else? Did you get that, Linda?
I did.
Do you have any questions about what I've done thus far?
No.
Okay. Now, the answers regarding paragraph 29. Nope, the court's going to leave that in there. The court's allowed to do that, but I highly suspect that's not going to be an issue here, but I'm still going to allow that. That's a standard right that's allowed to the probation officers. Again, it's only for 2 years or 12 months if the defendant is compliant with all the other terms or conditions. Now, as for a jail sentence, the court sentences the defendant to 24 days of jail.
It hears mitigation or the lack of it. Sympathy does not erase statutes, and goodwill does not cancel restitution. Interview 4. This is the philosophical breaking point. Thompson isn't just questioning probation terms, he's questioning the legitimacy of the authority imposing them. He invokes unalienable rights, constitutional language, and personal freedoms, believing these concepts override probation conditions. But this is where courtroom reality crashes into abstract belief. Rights exist, but they coexist with consequences. Probation is voluntary only in theory, reject it, and incarceration becomes the alternative. The judge carefully explains this balance not as a threat but as a fact. The law doesn't debate philosophy, it offers choices, each with a price.
I have to give a maximum end, which is 48 months. You don't have to serve that. You've already done your 24 days with 24 days of credit. Did you get that, Linda?
48 months.
24 days to 48 months with 24 days of credit. All right, Mr. Blazak, have I missed anything?
I don't believe so, Your Honor.
Go ahead, Madam Clerk.
Is that being held in abeyance, or is he?
No, he's already served his 24 days. So I gave 24 days of credit. So he has 24 months of probation. He's got a jail term of 24 days to 48 months with 24 days of credit.
48 months.
Yes, because it's a first felony, which, by the way, Miss Williams, if you're down in Lansing, tap somebody on the shoulder and tell them this doesn't make sense. But it's a first felony. I have to give it a terminate end. I have to give it 48 months.
Okay.
It doesn't make any sense. Yeah, so the look on your face, I share. We do this all the time. All right, so anyways.
Don't like the rules.
We don't write, I don't make the laws. No one's asked me to come down and make the laws, which, by the way, I don't want to do. Although somebody recently tried to start a rumor that I wanted to run for something else, Senate or House of Reps, which, by the way, no way in heck would I want that job. All right. Got it all there, Linda? All right. Thank you very much. All right. Mr. Thompson, I need you to come up here for a moment. Mr. Thompson, I have to go over what's called your appellate rights. You're going to initial one copy here. I'll put today's date. All you're doing is notifying receipt. Then you're going to take the other copy, because they're duplicates. So I just need you to put today's date, April 7th, and then put your initials there. When you place your initials there, you're not electing any rights. You are not waiving any rights. You're merely acknowledging that I'm giving you this one. All right, and I'll explain that to you in just a second. All right, back in a seat. This document tells you that you have the right to appeal your conviction and sentence. Based upon the fact that you were convicted at a trial, you have what's called a claim of right to appeal, which is different than filing an application for leave to appeal. If you choose to file a claim of right to appeal, you want the court to appoint an attorney, you may complete the bottom half of the copy that you're taking with you and return it to court within 42 days. If you choose not to file an appeal, or you choose not to request an attorney, you don't need to do anything with the document. Okay?
42 days to...
42 days. You have 42 days to exercise your right to an appeal. All right, hold on. I'll make sure I've got this all correct here on my forms. All right, I'm going to go around the horn one more time. Ms. Williams, anything further on behalf of the people?
People are satisfied. Nothing further, Your Honor.
Thank you. Anything further on behalf of the Department of Corrections, Mr. Blazak?
No, thank you, Your Honor.
All right. Mr. Thompson, do you have any questions about what we have done today?
At this point in time, I do not, Your Honor. And again, I just wanted to thank the court for their grace, and I apologize again for being tardy this morning.
Tell your friends. Thank you very much, sir. Good luck. We're adjourned. Oh, Mr. Thompson, your one piece of paper. Thank you. We're adjourned. All right, we're going to now take up the case of people of the state of Michigan versus... Is she here for another final?
Decatur.
Decatur. Oh, Decatur. There we go. Mr. Damian Decatur. This is going to be filed.
Finally, the resolution. Thompson is given his appeal rights, but the reality sinks in. Bankruptcy won't erase his obligations, and failure to comply means more jail. This is the sobering aftermath of defiance meeting the law. For anyone following sovereign citizen antics, this is the ultimate lesson: the system won't yield. If you enjoyed this breakdown, make sure to like this video, subscribe to the channel, and we'll see you in the next video.